And we're back. I'm Tanya Iser, an investigative reporter here at Channel 8, and we've all had lunch. We're all suitably full and waiting for the session to restart. They say it's going to restart at 1, although based on what I've been seeing, who knows.
So.
3:53 is when it really starts.
Exactly.
Right,
exactly.
Right. And not to pick on this proceeding in particular, but there are plenty of courts around Texas that say get back at blank o'clock. Sometimes the lawyers are there, most of the time we are, but things don't happen until some minutes after that. So.
Well, and in this particular case, every minute that we push forward is a minute we get a little closer to Laura Olson, which we're all on pins and needles for, because
exactly
all
right.
of us very much want to hear her testimony.
Right,
So,
right.
Bud?
Well, we were talking before the break about the motion that the House put forth that essentially rolls together the two issues of upholding the articles of impeachment and then whether to ban him from future office. The House wants the Senate to vote tomorrow on whether to do that. And it occurred to me over lunch, I thought, well, this is like calling a question in a meeting, and when you call the question, you think you're winning.
Right.
And so does this mean that the House thinks that they have the votes and they want to lay them out? It's like, they want to see what they've got, but does this mean that they think they have all 21 they need?
Well, or it could be that they are worried that, they do win that first vote, but then they lose the other one.
They lose the one on whether to bar him from future office, and there's some senator out there ready to flip that says, well, I want to remove him, but I want to let the voters decide. Yeah, that could be the case too. Well, so anyway, that was interesting.
And in what world do we live in, guys? In what world do we live in that the jurors vote on motions? Have you ever seen that before?
It's so weird. It basically is a way of checking where you are in the midst of the case, because it's probably not often that the juror is going to rule one way on an issue, but then rule another way when it comes down to making the ultimate decision.
And the jurors, this is a majority vote on the motion, but it takes a 2/3 vote to uphold the articles of impeachment. So
right.
It's really, this is really just an interesting little gambit by the prosecution. If you're following online, you're seeing a lot of comments, and a lot of the comments are, you're seeing the dramatics of the Republican Party of Texas play out. You're seeing the various factions. Right now, we see nationally, you have the Trump Patriot faction that's very strong. The people call them MAGA, but you see the people who are aligned with Team Trump no matter what. They will align themselves with Team Trump because they think that Team Trump will ultimately bring truth and righteousness and godliness to America, even if he does some bad things along the way. So you have people aligned with Team Trump. Then you have the traditional Republicans that many of them believe in Christian values and religious freedom, but they also believe in having a diverse nation of many faiths and having a democratic government, a democracy, democratic elections, where everyone gets to vote and everyone gets to decide. And so you're seeing kind of those factions. In Texas, basically we have the factions within the Republican Party of the religious libertarian faction that's funded heavily by these two West Texas oil men. I say oil men, Tim Dunn certainly an oil man, and Ferris Wilks in oil field equipment, that made all their money in oil, but they're all very strict conservative religious men. Ferris Wilks, an elder in his own church, leads his own church outside Abilene, that his family is so conservative that they were considered too conservative for the Church of Christ. And so they
Ooh, I have relatives that are Church of Christ.
They're Church of Christ. These are
very
too conservative.
They don't even do music in a lot of those churches.
They don't have their. I think every church is a cappella in the Church of Christ.
And we're Episcopalians. We're all for our hymns.
And I went to the Church of Christ growing up, that the church that didn't believe in Christmas, because nowhere in the Bible does it say to have a birthday party. So they don't believe in having Christmas. We had a non-religious Christmas with Santa and elves, but there was no connection to faith or religion whatsoever. But his church was considered too conservative. So you have these very conservative oil men who have sunk millions of dollars now into this particularly Ferris Wilks, into this national media empire of PragerU and the Daily Wire, all conservative media, and they're all pushing hard. And now we've seen Steve Bannon come in. We've seen everyone really but Donald Trump himself. We've seen Donald Trump Jr. tweeting on Paxton's behalf. Glenn Beck. We've seen this all this armada rallying around Ken Paxton, and it's all that they believe that Ken Paxton tried to overturn the election for Trump and is part of Team Trump and will be loyal to Trump regardless. And some of it is the same argument that it doesn't matter what he did right or wrong, he's on our team and we're going to fight for our team. You have the more traditional Republicans on the other side who are trying to uphold a religious freedom and Christian belief, but also religious diversity in Texas, and who are the conservatives who have led Texas for years, the Greg Abbotts, the John Cornyn's, and the people who are concerned with what they see in the Attorney General's office. I just named the two previous Attorneys General. Greg Abbott has been quiet, as he should be, but John Cornyn's spoken out about his concerns about the office. They don't think it's run right. And so, since obviously Greg Abbott hasn't, the fact that he hasn't said anything, is
that saying something?
Is significant. It's by not saying anything, and surely the fact that his DPS is under attack, brings, more into question. So, you have that, that faction, and then the accusations being thrown by the Trump campaigners, the Trump patriots, that this is somehow tied to the Bush family, or that there is somehow some connection with Johnny Sutton and the Bush family, that because George P. Bush ran against Paxton last election. I don't think that George P. I think he got a hint. I think he got wind that this was going on, but I don't think he was the one who hired all these ORU arch conservative, squeaky clean religious right prosecutors and put them in place, and then had to go to the Senate to ask for $3 million to pay for the legal settlement so you could fire them. None of what's going on in this case was George P. Bush's doing. This is all Ken Paxton's doing, and so the fact that George P. Bush may be watching it is not a reason to pin it on him. And anyway, I think most of certainly the Abbott campaigners were supporting Eva Guzman in that primary and not George P. Bush. There are about 5 factions of Republicans in Texas right now. They scratch and fight and claw, and it will be interesting to see whether there's enough unanimity in the party to keep them all together for the primaries in 2024.
I don't know. I don't cover politics, but this is outside my area, but it is going to be very interesting to see. I remember in college I had a professor, because I took a lot of political science classes, because I'm fascinated by politics, but I've just never really covered it. And he always, that whole saying about politics makes strange bedfellows. It kind of feels like we got a whole lot of strange bedfellows going on right now.
Yep.
Well, there are just some people who are usually on one. The people who usually support small government or for big government. The people who usually support fiscal controls are suddenly for big spending, and so everything is really inside out, and what you stood for 20 years ago or 10 years ago might not be what you stand for today. It has all been turned upside down. I don't think we've seen a case like this come to the Senate. I don't think we've seen an impeachment. We certainly haven't seen an impeachment like this. We have 16 articles with a lot of different topics and a wide variety of allegations. We haven't seen something like this where there's so much to work with, and they only have to affirm one article.
Victor, you've been in a prosecutor's office. Were you in the Dallas County DA's office?
Harris County.
Okay, Harris County.
So I've sat across from some of these defense lawyers and prosecutors.
So when you were in the Harris County DA's office, can you imagine the DA that you worked for doing the things that have been described as Ken Paxton, that his people who worked for him have said he did?
Absolutely not. So I came up under the administration of John B. Holmes Jr. In the mid-90s. And it was known by the prosecutors that when we left the office to go to the courthouse, we were to follow the traffic laws. We could not jaywalk. We could not walk against a light. We had to follow the rules, all the way down to the traffic rules, because John B. Holmes Jr. would be looking out his window, and if any prosecutor of his, any assistant of his did not follow those rules, how can they represent the public?
Right, and you expect prosecutors to follow the rules, and to have such an extraordinary situation where you have all these very high-ranking people to a person, I mean, all basically deciding the conduct we see is so extraordinary, and I keep going back to, it's not the foreclosure order, it's not the beginnings of the thing with Mitty, it's not the open record situation that sends them over the edge. It is the grand jury subpoenas. And one of the things that Darren McCarty said at the end during his testimony was they saw it as the criminal process being used to further somebody's aims in a civil case. I mean,
that's an absolute no-no, and under our professional rules that lawyers are governed by, you cannot use a criminal proceeding to further and gain an advantage in a civil process.
Have you ever been a special prosecutor?
I have not.
But how unusual would it be? Okay, so let's just say, when you're a prosecutor, to have a person representing a party to come to you with a list of people they want subpoenaed, and you're going to take that list at face value and go subpoena those people.
Well, the whole point of having a special prosecutor is that you want to avoid the appearance of being entangled with or subject to or influenced by the person in office. So if you're a special prosecutor, you want to make sure that you maintain the aura of independence. So that would say, I run my own investigation. I might listen to what you have to say, but I'm not going to let you direct me in how I do what I need to do.
Okay, they're talking. Oh, sorry. I thought Jay was about to talk in my ear.
Yeah.
Okay, so I'm watching the live Senate feed as well on my other screen, and we still don't see Dan Patrick back in the room. I mean, none of the senators have come back. It's as I figured, which was that they might have said one.
It's 103.
It's 103. I think that, so Victor, you're the attorney. Bud and I never got around to getting our going to law school.
That's right.
We went into journalism. I don't know what we were thinking sometimes. But walk us through the.
We get to hang around with the lawyers.
We do, and I know
There
a
you
lot of
go.
lawyers. About what the argument, the discussion was before they went to lunch, and what Dan Patrick has to decide.
So what we're talking about here is the admissibility of evidence, and what we've seen in the Senate chambers, what we see in courtrooms across the country. They're called bench conferences, and at a bench conference, the lawyers are arguing their positions for or against the admission of evidence. And what we're talking about right now is the admission of what would appear to be important evidence for the defense based upon how they have, I don't want to use the word grandstanding pejoratively, but how they have done some grandstanding outside of the Senate courtroom. So whether the pictures are going to come into evidence is going to be the focus once we come back from the lunch break, and that's what that break was about. I mean, that's what the bench conference was about before the lunch break.
Well, and they're probably still discussing it.
Perhaps that's right.
And it's kind of a what's good for the goose is good for the gander thing, because they've made the prosecution wait till 3:53 before they can put Laura Olson, Kim Paxton's former mistress, on the stand to answer questions.
Right.
And so they're basically saying, well, the defense has to follow these other rules too.
So it's
I mean, they didn't say
funny
that out
you
loud, but
say
that's
that.
how I feel like
No,
it.
but it's more than how it feels. There actually is the most important precedential authority for a lawyer in a courtroom is the vaunted case of Goose v. Gander, which says if you do it, it's going to turn back on you. And many times I have quoted that case, Goose v. Gander, say, Judge, what's good for the goose, good for the gander. You ruled this way for him on this instance, so I got it coming too.
Right, they're
In
saying
my favor.
if you want to bring these photos in, you got to authenticate when they came in, and there was also this 14-day rule and the metadata thing and
Right.
all this stuff. And so, I mean, how do do they come in, or should they come in?
Well, when you throw rocks when you throw rocks at somebody, you can't live in a glass house. So if you're throwing rocks at somebody because their procedural house is in order, you got to make sure your procedural house is in order as well.
And apparently their procedural house was not in order.
Well, we had a lengthy bench conference and we went to lunch, and here we are at 1:06. So there's something awry.
Well, and there is peril for the defense in this, because the defense wants to bring in all these photos that they say Angela Paxton took, Senator Paxton, in Lowe's and in Home Depot, of tiles they were looking at and countertops and everything. So the defense wants to introduce all those into evidence. Well, the prosecution, if those are all introduced, the prosecution may ask, to call Senator Paxton to the stand. It may ask her to testify, about everything she knows and everything else she knows about this case. So, there's the defense may or may not experience some blowback on this.
I've had a couple people with questions in the chat, and guys, if y'all are following the chat, I'm trying to keep up with questions, but there's a lot going on. People are asking, is Laura Olson the woman in the white dress? Yes, that is Laura Olson. One of our photographers got that footage.
She sure has gone to and from the chamber a lot.
Yeah, there's the video again. Yeah, that's Laura Olson. One of our photographers got this footage this morning. This was right around the time they announced that they were going to call her to the stand, and then of course we saw a flurry of activity, and then they announced that they didn't meet the 24-hour deadline and that it was going to be 3:53 before they could call her to the stand.
And she was a chief of staff to Senator Donna Campbell, who's a member of the jury. She worked as chief of staff for several years and was eventually terminated by Senator Campbell, but moved to Houston. And
why was she terminated? Do we know?
Well, she was terminated when the relationship with the Attorney General was discovered.
Oh, okay.
Supposedly.
I see.
But she moved to Austin and went to work, allegedly, according to the House prosecutors, went to work for Nate Paul.
Interesting. And apparently, and according to testimony we heard earlier, I can't remember from who, I believe, or maybe it was Busby that said it. A lot things are running together in my head, but it was revealed earlier that she's still working for Nate Paul.
Right.
That was during one of the first.
And during
that might have been during Mateer's testimony that we heard
she
that.
Still works there. Well, I think during the opening statement, Busby said she still works there, an honored employee and doing a great job, and glad to have her.
Well, you have a better memory than I do.
I think that was in opening statement. Busby rolled a lot in that opening statement.
Somebody's asking, Chris wants to know, how much time does the House have left? I don't know exactly. They were at a little over 5 hours this morning, and they were a little over 9 hours for the defense this morning. And they seem to have been, pretty. They seem to be, not counting like all these bench conferences and some of these various things against the House. So I don't know exactly. I mean, I'm guessing 3 hours, but that's a complete guess on my part. I mean, I'm throwing a number out without really knowing exactly, because I have no way to know exactly how they're calculating time.
Yeah, 3 hours, 2:45, something like that.
But I know if I'm a member of the House prosecution team right now, I'm going, whew, every minute that we don't come back is another minute we get closer to this.
And the reason we're saying this is because they didn't list Laura Olson as a witness until 3:53 p.m. yesterday. Is that right?
Yeah,
so
3:50. Yeah, I mean, I shook my head.
Until 3:53 p.m. today.
Yeah, and we've talked about this, but I have seen, and I think, Bud, you've watched a lot of the trial, and I've watched pretty much all of it, except for the point. I was watching yesterday during McCarty's testimony, but it was late. But there's been times along the way where I just thought they could have managed the clock better. If you have a limited amount of time, you got to be more judicious.
It's paramount.
Well, there were a couple of days where it seemed like a domino game in Hallettsville. It was just guys sitting around jawing, and nothing, I mean, no progress was made and the testimony wasn't valid. Victor, I stepped on you. Sorry.
No, you were making the point that I was about to make.
Well, you can go ahead.
When
got
you
plenty
have
of
a
time,
clock,
Victor.
when you have a clock, you have to manage your time effectively. I was telling you, Tanya, when we were getting a cup of coffee, that that means you have to think about what your proof is, what's necessary for your proof, what are your most persuasive points, and you have to order things effectively. And one of the cardinal rules under clock management is to avoid redundancy. And I think we saw that earlier, and it's coming back to bite the House managers.
Yesterday, late in the afternoon, was where I really felt redundancy, where I just went, why?
The banker, followed by the banker.
The banker was fine. That wasn't very long. It was because I think the banker was there to establish that some foreclosure sales did get affected.
Right.
That was what they were trying to do there. And Joe Brown, that's Joe Brown. They put Joe Brown on the stand. He's a former U.S. attorney out of the Eastern District.
Basically, all he testified, he said, I thought there was something fishy, and that summed up his testimony.
Well, but I think his testimony was to establish that there really was a competent, qualified person to do this, and not Brandon Kamek.
Yeah.
I mean, if you were going to select somebody, if you're the DA or you're the Attorney General, Victor, and you're going to select somebody to be a special prosecutor or an outside counsel, do you pick the guy with no prosecutorial experience, or do you pick the guy who's the former U.S. attorney?
You pick the person, if they're choosing between the two, you're picking the person with U.S. attorney experience.
Wow.
But even beyond that, there are special prosecutors who have been criminal defense attorneys, but the key is that they are criminal defense attorneys. They know the criminal process and can walk through its administration effectively.
You're looking for somebody to investigate the whole federal government and the DPS for $300 an hour. You know, I'm not sure how you're going to get. Of course, then they didn't wind up paying the bill.
No, they didn't. I mean, what is that, Victor? What does it tell you that they didn't ultimately pay Brandon Kamek? Told him he had to eat the $14,000.
Wow.
That's what Brent Webster told him, or that's what he says Brent Webster told him.
It's unfortunate for that lawyer. However, I can turn it on that lawyer as well, that when you have an engagement, it's incumbent upon the lawyer to set the terms of the engagement, and what we are allowed to do in the legal profession is take an advance payment or a retainer, and this is a good example of why that is a very prudent practice. Because you don't want to get too far out in front of your skis, get so far down the road, you're over $10,000 in legal services, and it's not going to be paid. That's not a situation you want to be in.
They took him to Starbucks, he testified. Then they told him he was fired. They told him he wasn't going to be paid, and then they tried to leave him there. And he didn't even have his car there. And did they even pay for his pumpkin spice? I mean,
I don't know. I mean, I kind of felt sorry for the guy. I was like, God, you know, he came across to me as very honest, and a little too trusting.
Well, he was the babe in the woods that they looked for to carry the ball on this, to be, I hesitate to say naive. He didn't seem naive. He just seemed inexperienced. But they were looking for someone who would be daunting enough to take on the whole federal government structure and state investigative force, and just go out and challenge everything about constitutional government and the state law enforcement all at once, please, and get some subpoenas out.
Victor, if somebody came to you, if Attorney General Paxton came to you and said, they want you to do this thing, I want to hire you to do this, and they put you in contact with the attorney representing one of the parties, in this case Michael Wynn, and you get a list, and among the people they want you to subpoena are lawyers that are involved in the lawsuit involving Nate Paul. They want you to subpoena records for federal magistrates, federal bankruptcy judges, U.S. attorneys, FBI agents, the DPS, the Texas State Securities Board. What are you going to do?
I'm telling them perhaps you should go talk to someone else.
Talk to Brandon Kamek?
There are red flags going up all over the place.
Yeah, when you
It's not something that you see in the ordinary course. To serve an array of subpoenas on the types of institutions and bodies that you're talking about.
I have never. Have you ever heard of such a thing?
I've not.
That's what makes it so stunning. It's like everybody I know that's in the legal system is like, what? They wanted them to do what? But you had to find some young, inexperienced attorney who had to consult with someone on how to file a subpoena because he'd never done a grand jury subpoena. He'd never been a prosecutor. And he gets pressured from Michael Wynn, this is his testimony, to let Michael Wynn go along with him.
I think your word is right, stunning.
Stunning. Go ahead.
Well, I was going to bring up too, I think it's pretty stunning. I didn't realize that being Attorney General of a state required 4 telephones, required to have required a separate secret Proton email account, a separate account on Signal that couldn't be found anywhere, traced, and required to have an assistant who gave you the use of his computer at times to write and send emails on, because that way they were under his system, and required the assistant's phone as well to make calls that you would then delete the whole call record from. I just didn't realize that those were in the job description for Attorney General.
It's unusual.
It's unusual. I think that's why we're here.
Okay, so now we got a live look up in the Senate chambers because folks were saying, oh, they're just chatting and what's going on in the Senate? Well, if you can see, guys, folks out there, there's not a whole lot of activity in the Senate. We do not see Dan Patrick. He has not come back. The senators are apparently still enjoying lunch. I think isn't that Busby? That's Busby right there. Yeah, that's Busby. Some of the House impeachment managers are back, but we don't see just a whole lot of activity going on in those Senate chambers.
Well, there's not a juror in sight.
No, the jurors are still, and that's another thing that's unusual, is normally in a criminal trial, you don't ever see the jurors. I mean, you wouldn't show footage of a juror in a real criminal trial. In fact, if you would like to go to jail, because a judge would put you in jail for doing that, but it's just a whole different, it's different. It's a political trial.
These jurors would like to be on television. Now, I think 6 of them will be running for re-election in 2024. They'd like to be on television.
Let's talk about, lots been made of Johnny Sutton, Victor. I mean, we keep hearing from, these whistleblowers that they don't have an agreement, the written agreement with Johnny Sutton. He's a former U.S. attorney out of the Western District. I forget which one is it, Western? And that they don't know how much they're going to owe him, and a lot is being made of that. How much of a problem is that?
Well, there should be a lot being made of that. As lawyers, we exist under ethical rules and rules of professional responsibility. One of the most important ones for client representations is that you have your engagement terms set out clearly and simply so that a client knows up front, is apprised what the terms of the engagement are, to include whether there's a fee and what are the terms of that fee. Even in pro bono engagements, we have engagement letters setting out what the terms are so that it's very clear and the client knows exactly what they are responsible for, what the lawyer is responsible for, etc.
About half of the Senate are lawyers themselves. How do you think they feel about this, the case where the people testify and have this one uncertainty surrounding them of, well, who's their lawyer and we don't even know how much he's making?
Well, it's hard to speculate. There are any number of things that could be going through their minds. It could be processing it the way I'm processing it, or they could be thinking, well, perhaps he's a busy lawyer and he just is pretty lax in the administration of his practice. Perhaps they could be blaming an office assistant for not getting the letter out. But ultimately, it's the lawyer's responsibility to make sure that the terms of the engagement are established.
It feels like by not having this, they've left themselves open to that question.
Right, and it is the defense is going to seize on any opportunity like that to cast aspersions or to create doubt.
And the dot that some are trying to connect online is that Johnny Sutton is part of the Ashcroft law firm at this time, which at one point had a contract with George P. Bush's General Land Office to secure land along the border to build the wall. Johnny Sutton was not one of the lawyers who worked on that contract. It was with 4 other lawyers with the law firm, but he is affiliated with the same law firm.
Yeah, and I suspect, and based on kind of what we heard in testimony, that Sutton was friends with some of these guys. He's Penley is a former federal prosecutor, and so they but you still open yourself up to something by just not. It's a dot in your eye and crossing your T thing, and you just feel like you should have expected that Busby's going to ask about it. You're going to get asked.
Right.
But here's the thing about it. In the eyes of the defense, he's a Fed, and they're trying to convince the jurors and the public that the Feds are all crooked, and the Feds are all running a big conspiracy to get Ken Paxton. So it's all the Feds, the Biden FBI, and then the unpredictable renegade DPS, and that it's all the Feds that are really out to do all this because Ken Paxton has lashed out so effectively at the Biden White House. What they leave out when they talk about this is that Greg Abbott sued, when he was Attorney General, he sued Barack Obama's White House 31 times. Suing the White House is something Texas Attorney Generals do, like eating cereal in the morning. It's not unusual for Texas to be opposed to a Democratic White House. We're always.
It's kind of par for the course.
Well, it's par for the course. We're always in direct opposition to a Democrat in the White House. And the next Attorney General, the interim has already been suing Washington, and the next Attorney General, whoever they may be, will be suing Washington if the Democrats are in the White House. That's what Republican AGs do in Texas.
Victor, we were talking earlier about this kind of legal clinic we're seeing play out. Are they going to play this in law schools? I mean, is this going to be, would you play if you were teaching?
I would. There's a lot to be gained here from seeing 2 experienced lawyers, and we're talking about the examination particularly of Drew Wick, to see these 2 legal stalwarts going back and forth on the rules of evidence, to see the lieutenant governor getting consulted about the rules of evidence. Regardless of what the rulings have been, what we have seen from the lawyers is what we see in courtrooms, but particularly from the prosecutor, we saw a really good understanding and application of the rules and the nooks and crannies of the rules, including exceptions to hearsay. And frankly speaking, arguments that things weren't hearsay, they were not hearsay under the Rule 801E.
But it felt like some hearsay got in, some didn't.
Well,
some stuff that was supposed to come in didn't come in. I was like,
flip the coin.
Sometimes it seems that way in legal proceedings, that things should go one way and they go another way. It seemed that early on in the examination, the lieutenant governor was a bit rocky on the hearsay rule. He seems to be getting some good counsel, and I seem to have seen some rhyme or reason to some of the rulings as the examination headed towards lunch break.
Victor, you said that these lawyers are putting on a good school, but I think that in many cases, particularly defense, is trying to school the lieutenant governor and trying to teach him to do things their way, and to tell him over and over, as Busby shouted, said, that's not the way this works, that's not the way this works, and shouted it at Lieutenant Governor Patrick. And it seems like that sometimes the school is directed at the judge.
Yeah, it seems that way. Something I want to point out as well regarding what we're seeing in this legal clinic on the rules of evidence is that in an actual courtroom where you have a jury sitting in the box, a jury of that aren't politicians or senators, you want to be very judicious in lodging objections, because it can get tiring and can turn a jury off. Now, there is an instruction that comes from the court in every trial that the lawyers have an obligation to assert objections. You're not to hold the objections and the assertion of objections against the lawyer. You're not to read anything into my rulings, whether I sustain or overrule the objections. But in real life, when it comes down to it, particularly if a lay jury saw the barrage of objections that they're seeing right now, it would not be good for the asserter of the objections, particularly if they're not being sustained one after another, time and time again.
Right.
Victor, where do the closing arguments go from here? I mean, aren't the two cases laid out pretty clearly? I mean, the prosecution just says, okay, we've proven that there's bad administration in this office. The law requires delinquencies or maladministration. Particularly in the handling of the outside prosecutor, the open meetings case, the MIDI. I mean, certainly they could say, look at all this. There's some maladministration of some kind here, some poor handling. And then the defense just stands up and says, look, they didn't really prove any of this. And they've just got a lot of people guessing, and a lot of people who didn't really see anything happen. Ken Paxton didn't get anything, and Nate Paul didn't give anybody anything. Nobody's proven that, and why are we all here? I mean, is that the way that this goes?
I think that's exactly the way it goes. And I think it's going to come down to what is the definition and meaning of maladministration. Is it a mistake? Is it a lapse in judgment? Or is there something beyond that but short of high crimes and misdemeanors?
Well, and as Bud pointed out earlier, the Texas Constitution doesn't use the words high crimes and misdemeanors. It uses delinquencies or maladministration.
Right. This was the Ferguson v. Maddox in 25, the Supreme Court.
Oh, the Supreme Court decision. That's not.
Yeah,
so
there's no definition at all in the Constitution.
Oh, in the Supreme Court. Okay.
Right,
Okay.
and
The Constitution does not set out any requirement for removal.
So, and that's the issue. We know what a high crime is. We know what a misdemeanor is. We also know what a mistake is. But what's going to get mushy for these senators, I think, is without any direction from the lawyers or any argument that fills in the blanks, what is maladministration?
This case that I'm citing in 1925, we know that Governor Paul Ferguson was impeached and removed. That was the
Can you
last
walk people
big
through what happened in that
statewide case. Well, I don't remember
It
all
had
the
to do with
intricacies of
like
that. It was selling pardons and quite a few other accusations. But he was impeached and removed, and then Ma Ferguson ran and was elected. I mean, they were populists that were very popular with the people, regardless of what they'd done in office or who they'd upset in Austin. They were very popular with the people. They were the voice of the little people. And so Paul was removed, Ma won, and Ma ran and won in his place, and so the Fergusons were right back in office. Paul tried to come back and run in 1925 and filed, and it went to the Supreme Court on whether he could file to run again, and he was questioning whether the clause in the Constitution saying you can never run again, whether that applied, and the Supreme Court eventually held that it did apply, and the Supreme Court wrote in the best definition we have, nobody is accused of a crime. The question for the Senate involves, these are the words, delinquencies or maladministration. The court wrote, and I'm quoting now, the wrongs need not be statutory offenses.
Mm-hmm.
Have they proved maladministration or delinquencies?
And that's the question, Victor.
That's the question. The case almost set a standard that allows some political judgment because there is no definition of what it is. That's why I said, is it a mistake? Is it a series of mistakes? Is it a certain amount of mistakes that demonstrates that the administration is not just not the most astute, but that there's something awry? What we do know is that it doesn't have to be a statutory violation. It doesn't have to violate the law per se. Perhaps it's just the appearance of running a ship that's not quite right.
Victor, you struck exactly at the concerns about Texas impeachment law, and they were borne out in the Paul Ferguson impeachment when presiding at the impeachment trial was Lieutenant Governor Bill Hobby, presiding over the removal and impeachment of the governor. Of course, if the governor were removed, he would become governor. So he was the judge over a trial that would eventually see him take over the governor's office. And so that conceivably could happen again, that you could have the lieutenant governor presiding over the impeachment of governor when the lieutenant governor has this to gain.
Right.
Okay, so folks, Jay, you want to bring that back up? That was the live look. So right now, I'm going to have Jay bring that live look back up. As you can see, still not all the senators back at their desks. Well, that's John Whitmire, right, out of Houston, that just passed by the camera.
Gosh, he's aged.
But we're definitely not. This Senate is definitely not back in session, and I am guessing, Victor, that they're still back there trying to hash out this legal question about this affidavit. But it also places us about 2 hours and 20 minutes out from.
That's exactly
from
right.
Laura Olson.
Maybe the senators are hanging out till 3:53. Maybe they're.
Well, I was going to leave that to the political analysts, but that did cross my mind that there could be some Democratic senators who are,
taking a long lunch
or stuck in traffic.
Yeah, but I think if that was the case, I think that Dan Patrick would they might send out the squad cars for him. So I don't think they'd play around about that.
It is 2.5 miles to Polvos, I saw. So if everybody went to Polvos, there might be some traffic on Congress coming back. Apparently, everybody at Austin goes to Polvos.
I feel like I want to go to Polvos the next time in Austin. I feel like it's a great place. I feel like the food is really good. I mean, and I've never been to Terry Black's. I feel like I should go to Terry Black's.
Terry Black's is
really good.
Open here in Deep Ellum.
Why haven't I been there? I don't know.
Yeah, it's across from Pecan Lodge.
Oh, I've been to Pecan Lodge. Pecan Lodge is great. I love Pecan Lodge. Yeah. Okay, so I had a couple questions from folks in the chat. It's hard for me to keep up sometimes because the comments are rolling so fast, and so I try to write them down when I see them. Somebody asked, what obligation does Lieutenant Governor Patrick to follow the recommendations of the judge who is sitting beside him?
Oh, so.
Does he have to follow those recommendations? I don't think so.
I think it's just purely advisory. It's very clear, however, that whatever she's saying, we don't know if he's following the advice or not, but it seems to me that he is at least listening to and considering what the advisor is saying.
I mean, it feels like he's really trying as much as he can as a law and lawyer to do the right thing.
It appears that way, which is why I said earlier in this broadcast that whether he's an effective judge, meaning he's the best judge on ruling on motions or objections, is a question that could be debated, but it seems to me that he is demeaning himself as a judicial officer.
You know, I wonder how she's passing word. You see her whisper in his ear sometime, but sometimes he speaks without her saying. You wonder if she has a playing card that she's flipping over, or what the signal.
Sustained, not sustained.
Yeah.
I mean, or maybe he feels like he's kind of getting the hang of generally of the hearsay thing.
That could be it.
Yeah.
We're waiting on the ruling about evidence. So
yeah, we are. We're still and that's. I feel like that's what the delay is they're trying to decide how to rule on this, right? I mean, if you were advising him, do you think they're going back there consulting with maybe, I mean, I know this is not an appealable thing, but maybe they're consulting with appellate attorneys or something, or I don't know.
It could be.
I mean, it's hard to say.
We were waiting on the countertops. It's
Exactly.
all about the countertops. So we want to know whether we can see pictures of the countertops. Can we see Senator Paxton's pictures?
Okay, Jay is going to
have the metadata.
Jay is going to put the countertops back up.
Bring back the countertops.
These are the counter. This was
okay.
That was shown at a press conference.
These are the countertops that were in the Paxton home. Busby held them up at a press conference and said, "See, they didn't even change the countertops. These are not the granite countertops." Well, the House didn't allege that they bought the countertops. The House alleged that they discussed buying the countertops, and that the guy doing the remodeling said he was going to have to ask Nate about that. So nobody ever said they followed through and bought the countertops. So, but these are the countertops. This is the Attorney General's kitchen. It's been widely discussed, and the question isn't whether those are nice, fancy Italian marble countertops or anything like that.
I mean, they're not bad looking countertops. I mean, they're okay.
They're a little dated.
A little bit, yeah. Victor, what did you think about the fact that this contractor refuses to come testify?
You know, it's one of the things that we have in our jurisprudence is the ability to refuse to testify. And in the criminal context, at least, when it comes to what we can read into that against you, we're not to read anything into it. So perhaps you could say he has something to hide, but somebody might say that's pretty prudent to keep yourself out of the crosshairs and to exercise your constitutional right to refuse to participate.
Bud, maybe you know the answer to this, but one of the producers is asking me, does Paxton have to be there for the verdict? Do we know? Does he have to be there?
Odd.
I don't. I mean, it felt like I'd have to go back. I need to go back and read the rules, but it mainly addressed that he had to be there for
For the start. I don't think that the rules required him to be there for the verdict, but I didn't read, and we should explain these rules, this trial, this removal trial, I call it, trial of a court of impeachment, is being conducted under a long set of rules, debated and voted and passed privately by a Senate committee chaired by Senator Brian Birdwell of Granbury. And they set out all the rules for how everything would be conducted, including some that are stricter than what the Constitution calls for, such as the level of proof that would have to be, beyond, without a doubt, and instead of beyond reasonable doubt or something like that. So there's this long set of rules. So now they're debating, exactly what the rules say about admission of evidence, and I don't know where in the what it says in the rules about Ken Paxton's presence. I don't think so, because really, legally, constitutionally, Ken Paxton
All rise.
is
The
not
Court of
on
Impeachment
trial.
of the Texas Senate is